So it is certainly a burning problem for most of the SSCs and consequently for the most of the tax practitioners, sir.
Excellent, excellent. Now I would just like to, of course, it's a very, very thorough, very comprehensive reply. But I'd just like to, in terms of procedure, you see, these are problems which plague us day in, day out. And they can have very, very serious consequences for an upcoming or for a running business, where there's a huge demand. Your income is 100 rupees, it is assessed at 100 times the returned income. You don't have the amount to pay, your banks are attached. Strategically, what one ought to do, I think, is, of course, have a very comprehensive application for stay, move to the next higher level. Basically, there are two channels, as Mr. GHIA said. One is that if you have filed an appeal before the CIT appeal, which you must have, evoke the jurisdiction of the CIT appeal, insist that he passes an order for stay, cite the various High Court rulings, Supreme Court rulings, which qualify that the CIT appeal passes an order, but then essentially it's an administrative remedy. I feel, Mr. GHIA, then one can keep going up the ladder. You go to the CIT, then you go to the CC. Sometimes you can even go to the board. And when you do that, you write to the next lower authority that, look, I am now prosecuting the next higher authority, please wait. Do not take any coercive measure till the next administrative authority takes. And then build up your case to such a level that if the final remedy is not available, you go into a writ. And in the writ, three important things are to be considered. One, you should have a prima facie good case. Two, your financial hardship is a very important factor. If you have very solvent, very liquid, the courts would say, well, pay some amount. But if you are not liquid, financial disability is there. And then, of course, is your other credibility and other factors which come in. Anyway, now coming to the next question. Sir, is there anything that you would like to tell us in this matter?
So far, tribunal is concerned, we are generally liberal in granting the stay. As Mr. Ajay rightly pointed out, there are three things which are to be looked into. First is the prima facie case, second is a financial condition, and third is a balance of convenience.
Yes.
If all the three conditions are satisfied, tribunal generally grants the stay subject to making up the part payment. And one thing I would like to clarify, as Mr. GHIA used the word, कि sometime an SSC makes the payment of 50% to buy the peace. I will tell you an interesting thing. One day some matter was being argued in the tribunal and SSC made certain surrender before the assessing officer, and he said, कि sir, I made a surrender to buy the peace, so no penalty may be levied. The argument of the DR was, कि sir, we are not selling the peace. So please be aware, don't do anything to buy the peace, do anything which you feel is correct as per law.
Sir.
Very, very beautiful.
Can I add one small point?
Yes.
That it would be advisable for an SSC, particularly at Tribunal and CITA level also, that while one files the stay application, one may also file an application for early hearing of the case. So it will show a preparedness on his part, that I am ready and willing to argue the case now and now only.
Yes. Now, very good, sir. Now let's move on to the next question. Mr. GHIA, you just mentioned that one has a right of appeal in respect of an order passed by an adjudicating authority, and that right is enlisted in section 246A, and it's a very exhaustive list. Is that the only list? Can there be a case where the section doesn't feature in 246A, yes, the assessee suffers a jeopardy, he has a liability, he is aggrieved? What in respect of a grievance and that grievance not finding place in 246A, does he have an appeal remedy? That, I think, should be an important issue. And Mr. GHIA, if you could throw some light on this.
A very pertinent question again, Ajay ji, in the context of list of appealable orders under section 246A1, that although the list is comprehensive, although it is not inclusive, but the terms used in 246A1, particularly subclause small a, are giving very, very wide scope as interpreted by many Supreme Court judgments also, because the words are, SCC denies his liability to be assessed under the Act or objects to income assessed or objects to amount of tax determined. Now, crux of the decisions of High Courts and Supreme Court particularly is that whenever there is a liability being fixed up on the SSC on account of either interest or even tax, and whenever there is a liability of either tax or reduction in the refund, all these aspects are covered by the term aggrieved, and as well as he objects to either the tax determined or to the income determined, income assessed. But even then, there are many orders which are not enlisted in 246A1 and which are prima facie not covered even in this wider terminology of these words also. We can just exemplify a few and we can try to find out what may be the remedies in such circumstances. For example, it is very usual for an SSC to apply for non-deduction of TDS or for lower deduction of TDS, either in the context of say 197 or in the context of 195. Now, these are not the orders which are appealable under 246A1. But courts have taken consistently view that since these are also concerning the determination of the tax ultimately, and therefore these are appealable orders. There may be some other orders like only interest is levied under section 220. Now, only interest is levied under 220 is not in the form of an order which is an appealable order. In that context also, there are two views that one may then one may consider that interest ultimately can be computed on arithmetical basis only, and if there are mistakes in interest calculations, the cases should be apparently be covered by the cases mistake apparent from record. And once it is a mistake apparent from record, then one can apply under section 154, and if 154 is denied in a case, then 154 rejection is also an appealable order. And the courts, as I mentioned, have taken a view that anything concerning the income or tax is ultimately falls in 246A1, particularly subclause A. So, and ultimately, if the right to appeal is denied for whatsoever reasons, for any of the reasons, then one will be left with no alternative but to file a writ petition in the High Court that since the order is not appealable and therefore there is no alternative remedy but to approach the Honorable High Court only.
Very well put, very well put. Now, just to close this issue, as Mr. GHIA pointed out, 246A1 says that you have an appeal remedy whenever you deny a liability. Now, the general philosophy is behind the appeals is, and behind the section is that a construction which advances the remedy and not retards it ought to be followed. Meaning thereby that if you are aggrieved, then the scope that has of an appeal is so liberal that you can try and bring that order within the purview of the sections enlisted under section 246. Not to just to give an example. Let us say you have a defect in the return. You file your return of income, there is a defect notice. So 139.9, the assessing officer asks you to remedy the defect. You are not able to, or you do not. Then what happens? He passes an order under 139.9 holding your return to be defective. Now that per se is not an appealable order. But the courts have said, yes, you can file an appeal. And you can say that this is an order which is akin to an order under section 143.3. Because it again ultimately leads to a liability. Therefore, the right to an appeal is a right which the courts want to give you because of the democratic structure that we have. That everybody has a next year, has a right to go up and seek a remedy. And a liberal view is taken. Is that correct, Mr. GHIA?
Very correct. In fact, just to corroborate with your view, the same view was taken in the case of Melaram and Sons by the Honorable Supreme Court in 29 ITR 607.
Yes.
That such rejections of appeal by CIT also are appealable at tribunal level because they are ultimately affecting the income assessed or tax determined of the SSC. Any objects to the same?
अच्छा, अब साहब एक बड़ा important, the very very important issue that comes up is, and where people are very anxious. You see, very often it happens that when you are undergoing the assessment procedure, then for various reasons, sometimes you are forced, compelled to offer an amount to tax or offer an income, popularly called surrender of income. You say, sir, all right, in order to buy peace, I surrender this income. Now, once you surrender the income, you don't dispute the taxability of that income. Do you still have a right to appeal against your offer, the surrender? After all, there is no liability now. I mean, why would you deny a liability? So, firstly, are you entitled to file an appeal? And yes, if you are entitled, what would you argue before the CIT appeal? What would you state? You have already surrendered. You already conceded. So, therefore, Mr. GHIA, this is a problem which I am sure plagues a large number of practitioners as to what do you do? So, what are your views on this? And here, sir, Agarwal Sahab, whether you like it or not, I will have you to offer your views. Again, your ultimate views.
I think certainly, we will certainly like the issue to be concluded by Agarwal Sahab only in the fitness of the things. And Ajay ji, you also practice at a high court. So you will first of all agree, Ajay ji, with me that in civil litigations, once the parties have consented to the order, then the order cannot be challenged at the higher forums for the reason that there is a principle of estoppel, that once having promised something, once having agreed to something, the same matter cannot be thereafter reopened in higher forums. But there is no similar provision, first of all, in the context of income tax proceedings, and probably very rightly so, because under the revenue law litigations, there is nothing like principle of estoppel. And the kinds of the orders, Ajay ji, you mentioned, are either falling in 143.3 or maybe in 144, 158 BC, or maybe with reference to 153 ABC, etc. also. But ultimately, per se, these are all the orders which are falling in the list as contained under 246A(1). And therefore, per se, the order is challengeable because it is an order, say, for example, passed under 143.3. The issue would be whether the SSC would succeed in challenging that point to which he had consented for whatsoever reasons, as you mentioned. Then probably we can divide the issue into two parts, that the SSC has agreed in the context of factual aspects, like in the context of confirmation of loan, confirmation of gifts, allowability of certain expenses. And while in most of the cases the AO is proceeding to verify or investigate the issue, during the course of assessment, during the court of verification or investigation, the SSC says, I am agreeing that this is my income and may be added to my total income. With the result that at the instance of the SSC, the assessing officer has stopped from further investigating the matter. Now, in such factual issues, if thereafter the SSC has to say at CITA level that although I had agreed at that time, and because of my agreeing, the learned AO stopped investigation, now I want to reopen the same issue again, he will not certainly succeed for the very logical reasons. But there can be some issues where, whether at the instance of the AO or suo motu on the part of the SSC has a particular interpretation of the law, that he claims some deduction, he claims certain incentives, but his claim was based on a particular interpretation of the law. And during the course of assessment, he feels that his interpretation of the law was wrong, and therefore he agrees to the addition. Now, this is an agreement on the part of the SSC, primarily based on his interpretation of the law during the course of the assessment proceedings. Thereafter, it may happen that due to subsequent court decision or due to his change of opinion, change of interpretation by some further advices or on his own, he feels that he agreed to the addition on a misconceived view of the law, and there cannot be a dispute that he can invoke such issues. He can invoke such issues at the appellate forums also, because there cannot be a stoppage. He cannot be prevented from the benefit of correct interpretation of the law. And the authority CITA as well as the Honorable Tribunal, they are ultimately to decide whether the tax or the income has been determined correctly or not. And therefore, sir, for your consideration, my submission is that on the factual aspects, most of the times the SSC will not succeed. except in a case where appreciation of the facts itself can be a question of interpretation. And on the interpretation of law, the SSC may succeed if he has right reason that his interpretation was different and it has thereafter changed. Sir, for your consideration.
Before I express my view, I would reiterate that it is my personal views and not any authoritative view, as GHIA Saab presented कि there would be a final view. No, it is not final view. It is only a personal view
And
of
only
Mr.
academic, sir.
G.D.
Only-
Agarwal.
Yes, sir, and only academic.
I entirely agree with Mr. GHIA, and he rightly divided the agreed edition in two parts. One is where the agreement is based upon the law, and second, agreed edition is based upon the facts. So far, agreed edition based upon the law is concerned, SSC certainly has a right to hesitate before the appellate authority, because it is almost settled position that there is no estoppel against the law. But so far facts are concerned, as again he rightly pointed out, कि if some inquiry is initiated by the assessing officer and then SSC agreed to the addition so as to stop that inquiry, AO stopped the inquiry because the SSC has agreed to the addition, and then SSC wants to re-agitate before the CIT appeal, ordinarily it would not be permitted. And when even if SSC is able to pursue before the appellate authority that he had agreed for the addition under some misconception of facts or under some misguidance or misadvice, then also the matter would be sent back to the assessing officer to start the inquiry again. So if you are trying to take the advantage of getting the assessment proceedings stopped and then take the advantage at the appellate stage, that will not happen, because then again at least in the matter comes before me in the tribunal, I will, if at all, admit if SSC wants to rebut the agreed addition, then the matter would go back to the assessing officer for further inquiry. The only change situation can be on facts, as Mr. GHIA quoted the example of, say, cash, credit or gift. If before the assessing officer you were not able to get the confirmation, maybe the creditor was out of the country, and then you thought fit कि if you are not getting the confirmation, let it be agreed. But later on the person came back to the India and he gives you all the details, and then you can certainly plead before the appellate authority कि sir, because of this constraint I was not able to give evidence before the assessing officer. Now I have all the evidences and I have no objection, let it be inquired by the assessing officer. In such circumstances, maybe appellate authorities may allow you to argue on even the agreed edition.
Excellent, sir. Excellent, sir. I think a very comprehensive response. I will just summarize. The principle of law is, as far as income tax is concerned, that you can collect only the legitimate tax and nothing more. Fairness, justice and equity are the hallmark of our system. Now therefore, read with this is the judgment of the Supreme Court, which is a master judgment, which I am sure should be always there in your library, is that of Pulangod Rubber, 91 ITR 18 Supreme Court. Now there, the person in the return of income itself had suo motu offered some amount, and therefore thereafter retracted, said wrongly given. So the Honorable Supreme Court said that admission is an extremely important piece of evidence, but it is not conclusive. And it is open for the assessee to show that it is incorrect. Therefore, when you make a concession in law before the assessing officer, it's a very good evidence and it will always be held against you. But if, like Mr. Agarwal said, an excellent example which he gave, that you have a loan, you have taken a loan from somebody, and you have a bad relationship with him, you're not able to pay him interest. He says, well, I'm not going to cooperate, I will not give you a confirmation. And if you do not file the confirmation, it is added under section 68 of the Act. But later on you mend your ways with him. And when you are before the CIT appeal, you are able to get that. So if you are able to show those circumstances, produce that evidence, of course the burden then on you is very heavy. Why would the CIT appeal come in? But yes, again, equity, fairness, justice, which is the trademark, and only the legitimate tax can be this thing. Therefore, you can, under some circumstances, these circumstances, withdraw. Now, sir, let's come on to GHIA Saab. Some of the procedural aspects. Now, how strict and rigid are the procedures relating to the filing of appeal, the signing of appeal, how the filling up of the form, how strict are they to be adhered at? Meaning thereby that if, let us say, I am unable to sign, let's say it is signed by the authorized representative, an appeal memo, and not by the director or the managing director. What happened? Am I off at the threshold? Do I get justice, or am totally blocked? What would you say, Mr. GHIA? Let's start this.
Ajay ji, as you will also corroborate, the requirements of filing appeal as far as procedural aspects are concerned, which form to be used, who is authorized to sign, because the rule of section 140 will certainly apply, who is authorized to sign a return can also sign the appeal, and payment of the fees before filing the appeal, etc. There are many procedural aspects, and all the procedural aspects are compulsory to be followed. At the same time, most of the procedural aspects can be termed as directory vis-a-vis being mandatory, and therefore ultimate legal view would be certainly that for the procedural and technical aspects the appeal will not be rejected, because in most of such cases, unless the aspect goes to the root of the validity of the appeal, unless that is the view taken, the aspects will be termed as at the most defective, and a defect can be removed after the SSC is being given opportunity of removing the defect. In case the SSC thereafter also fails to remove the defect, then of course the appeal may be returned or rejected at the particularly tribunal level after the registrar obtains the orders of the bench. But more important aspect in such context is that one should be very thorough about the procedural aspects also, for the reason that it is fine to say that the defect can be rectified also, but it entails a lot of labor, lot of delay, because ultimately SSC does not benefit by any delay in decision about his appeal, particularly in the context of recovery proceedings and penalty proceedings following the assessment. And secondly, it certainly creates a kind of little aspect about his own impression also, that if some very grassroots level mistakes are happening, then the authorities, the honorable tribunal members may not be appreciate of such things happening by the authorized representatives, and therefore the view can be taken as most of such procedural aspects are compulsory, although not mandatory. Directory can be removed after opportunities being given, and one should take a very strict view as far as one is a consultant or authorized representative.
ठीक है नहीं.
Yes.
In general, I agree that procedural aspects are to be complied with, and whenever there is a defect, he will certainly get an opportunity from the appellate authority to rectify the defect. But I have one reservation: it is not directory. All procedural aspects are compulsory, but that is a curable defect. Even if defect is there, that is curable. He will get an opportunity, but he will have to remove the defect.
Perfect. So, curable, a liberal interpretation, because it's a mere procedure, it doesn't go to the root of the matter. Please remember to read 276 ITR 1, a Delhi High Court judgment, where the memo was signed by the authorized representative, which is absolutely incorrect, not warranted by law. Memo of appeal has to be signed by the managing director, failing which the director. But they said it's a curable defect. They sent it back and said kindly pursue the appeal activity. Yes, Mr. Nanda.
Thank you, Mr. WADHWA. I was deeply engrossed in the discussions. Very discussions, technical, par excellence. But for every good discussion to assimilate and to percolate to lower levels, we need to have a small break. So, ladies and gentlemen, we go for a break of 10 minutes. We'll assemble exactly after 10 minutes. Thank you so much. Welcome back after the small break. Ladies and gentlemen, professional practice is something that not only creates value for us, it creates values for all the stakeholders who are engrossed in the system of practice. We chartered accountants are termed as partners in nation building. More importantly, when we do our practice, it is the perspective which is important in life. The most important thing is how you view things and how you draw your inferences from those things. I'm reminded of a touching story which I would like to share. There was a boy. The story relates back to the 18th century. He did his graduation, went up to his father, told his father, "Father, I have become a graduate." The father was very happy, hugged his son. He said, "Son, you have brought a great name to our clan. Nobody till now could become a graduate. Tell me what I can give you as a gift." Son said, "Father, please give me a brand new Mercedes, sports car Mercedes." Father said, "Don't worry, my son, you'll have it." Son said, "Father, tomorrow I have my convocation where I received a degree from the governor. Would you give me there?" Father said, "Don't you worry, my son, you'll have it there." The D-Day arrived. The boy received the degree. And as he was receiving the degree, the father with his friend came up to the dais, congratulated his son. The son was impatient. "Father, where is my gift?" The father handed him a wrapped packet. He opened the packet. Oh God, it was a Bible. "Father, you are a promise breaker." Saying so, he threw the Bible on his father's face. The father also couldn't take this insult before the whole city. Had a massive heart attack, died on the dais. 20 years from now, 10 o'clock at night, the boy is trying to read the Bible. The father